Good afternoon, everyone. I can see that people are still coming through and the numbers are climbing, but we did promise that we would start at 1 o'clock because we only have an hour. So thank you for those that are giving up their lunch hour to be with us and hear what we have to say. For those that don't know me, my name is Angela Cathari. I am one of the non-profit partners at Moore Kingston Smith. I'm also head of education here and have been in the sector for probably over 25 years now. What we thought we would do is we are going to introduce each of the team. Well, they will introduce themselves very quickly. We do and have had a lot of questions in the interface of putting the webinar invite out and to even today. We think we fielded all of them in our Q&A session that we're about to do today. We will try and get through as many questions as we possibly can, but an hour is quite short based on the number of pages we've got in front of us. But if you do have a question, please use the Q&A that sits at the bottom of your screen. We will keeping an eye on those. Hopefully your questions will be answered. If we have time at the end, we will deal with some of the things that we haven't answered. But it could well be that you might have to take it offline and talk to our HRC department, who are represented by Donald, Joe and Dinah in front of you. And some of your questions might be pertinent just to you as a school, and our team might need a bit more information. Unfortunately, we don't have the time to deal with that here. So again, you might have to take that offline, but we'll see how we go and we'll try and get through as many as we can. So I'm going to now pass over to Donald, Joe and Dinah, who are going to say a little bit about themselves so you understand where their expertise is, and then we'll start the Q&A.
Hello, so starting with me, I'm Donald Moon. I'm Moore Kingston Smith HR Consultancy's employment law consultant. So my job is to keep clients and the HR consultants on the straight and narrow regarding all employment law matters.
Thanks, Donald. Hi, my name's Dinah Patmore. I'm one of the strategic HR partners at the HR Consultancy, and I work with clients on developing their people plan aligned to their business plan, along with many other types of projects. I've worked in various sectors over my HR career, but I'm focusing within MKS mainly on the non-profit, manufacturing and including education sectors within non-profit. And I've been looking into this case with interest and have already been helping some clients with some of the calculations that have been wonderful. So looking forward to answering some of the many questions that have been coming in.
Hello, I'm Joe Regan, a strategic HR partner for HR Consulting. Formerly, I was HR director for LK Bennett Group, new to MKS and supporting with multiple sectors within MKS HR Consulting.
Thank you, everyone. So as a quick revisit, what we thought we would do, I'm going to just let Donald, just for the benefit of everyone joining us so that we're all on the same page, just reiterate where this all came from very quickly before we dive into our first question. So over to you, Donald.
Thank you, Angela. So we're here today really because of a Supreme Court case. And it involved a visiting music teacher at a school that was run by a trust. She was on a permanent 0 hours contract. She had no minimum working hours and was paid only for the hours that she worked. And in around 2011, the school changed the basis upon which it calculated her entitlement to holiday, so the number of days she got, and her pay. So what it started to do was apply a multiplier of 12.07% to in effect prorate everything and calculate the pay, instead of basing it on an average over a reference period. That was in line with the ACAS guidance at the time, and I presume it was much easier for the school to do things that way. But she lost out because of it, and so she brought a tribunal claim. Tribunal dismissed her claim, but the Employment Appeal Tribunal, Court of Appeal, and now the Supreme Court have decided that she was correct. So really there were 2 points to this judgment. Firstly, about the entitlement, so that's your 5.6 weeks entitlement under statute. So what the court said there was that permanent part-year workers are entitled to all 5.6 weeks annual leave per year, and that's regardless of how many weeks they work in that leave year. And then they moved on, having done this, after dropping this hammer on employers, they decided to move on to discuss pay. and they said that it's unlawful for employers to use 12.07% to calculate holiday pay for irregular hours workers. What they should be doing is using a reference period, and you will have seen lots of references to 12 weeks, but actually we could ignore that because the position now is that the reference period in the UK is 52 weeks. So the issue for you as employers is that this is a Supreme Court decision, so it can't be appealed. That now represents the law in the UK. So the only thing that can happen is Parliament could intervene to tinker around with the working time regs. I know that there's probably going to be a lot of pressure groups getting together to pressure the new PM to do just that, but we don't know how high this might be on a priority list at the moment, or whether that will be successful. So for the moment, this does remain the legal position in the UK.
Thanks, Donald. No one is very happy about it. Always these things have unintended consequences on every sector, and the people that are logging in to hear this today come not just from the education sector, but across our charity sector. So we know that this has far-reaching consequences. So the first question that I want to have asked, and we're going to go to Dinah for this, does the case relate to holiday entitlement for part-time workers as well as part-year workers? And there is a slight distinction.
There is a distinction, yes. So the answer is no. Permanent part-time workers who are not part-year workers will have their leave entitlement prorated in the usual way. And what I mean by the usual way is that if somebody works, for example, 2 days out of every 5 days, and they work every week of the year, they will accrue 40% of their 5.6 weeks annual leave for the year, because they're working 40% of a week. This probably won't apply to many, if any, roles in schools. However, it may well apply to other sectors, and it probably will. So certainly other non-profit clients that might be online might benefit from that knowledge.
So then, does this apply to any holiday entitlement over the statutory 5.6 weeks then?
No. If you provide more than the statutory 5.6 weeks minimum holiday, it is an option to be able to calculate any additional holiday pay in a different way. How that is kind of open, really, as long as it's documented in the contract of employment how you're calculating that additional piece of holiday. So for example, you might say that anything over and above the 28 days or 5.6 weeks is going to be calculated at your normal basic salary. Yeah, so not including any additional remuneration or anything like that. However, this could become a bit of a admin nightmare, a massive headache for employers. So I think a lot of employers are choosing to just treat the whole lump of annual leave the same, so as to avoid having to do manual calculations for the additional piece as well as the statutory piece. So yeah, that's the answer. The answer is no, but maybe you might be better just to keep it simple.
I think, yes, I can understand it. I suspect it'll come down to costs, depending on the size of the organisation. Now, this is the one that really did surprise me when I came to you, Dinah. But so if an employee works for more than one employer, how does that work?
Yes, we've been asked this quite a lot recently, specifically, and yes, it is a surprise to many that when an employee works for more than one employer, doesn't matter how many, they might be working for 10 different jobs, they are entitled to annual leave from every employer that they're engaged with, and that is based on the statutory 5.6 weeks minimum as well.
I'm going a little bit off piece, but we're basically saying that if someone works for 4 different employers in a week,
yeah,
and every week, for example, just for argument's sake,
yes,
they are entitled to holiday pay for each one of those employers.
Absolutely, at 5.6 weeks.
That is the one that,
based on the 5.6 weeks, yes.
Yeah, okay. That's the one that actually raised a lot of eyebrows with our client base. Dinah, last question for you at the moment. What is the best way for us to calculate a part-year worker's holiday pay right now?
Okay, so the pay, it's working back 52 weeks from the date of the annual leave. So you've got an employee who's taking their annual leave now. So you work back 52 weeks and you try to get 52 weeks worth of earnings. And that's starting at the first full working week. So remember to include anything that could qualify as ordinary remuneration. So anything like a car allowance or other allowances, any regularly worked overtime, any bonuses that are given on a regular basis could be argued to be part of their normal remuneration. And then if there are any weeks where the person hasn't worked in that 52-week period that you're looking back on, then you discount those weeks and then you work back further up to a maximum of 104 weeks until you get your 52 weeks worth of earnings. And then once you've got your 52 weeks worth of earnings, you can work out the weekly average pay. If you can't get 52 weeks, then just use the number of weeks that you have got within that 104-week period, and then use that as to get your average weekly amount.
So not very easy.
Not really, because no, I mean the actual maths is easy enough, but it's just, you know, it's just the headache of you know, having to, at the point of someone taking annual leave, then having to, right, okay, look back over the last 52 weeks, as opposed to being able to, at the beginning of a holiday leave year, being able to say, right, this is our weekly amount for everyone moving forward for this holiday leave year. You know, technically that's not how we're supposed to do it. Although I do know that some clients do it that way, and you know, and they don't get questioned on it. But if we're doing it correctly, then we have to take the 52 weeks prior to the holiday being taken.
Thank you. So it's just probably worth saying that that was a lot of information. We are, to everyone that has signed up, going to send out the Q&A that we're going through at the moment with their respective answers. So that should help you make some reference to some of the information coming out verbally here. Also, it's worth just mentioning those that are members of the Independent Schools Bursars Association, they do have their own calculator spreadsheet. Please use it, don't reinvent the wheel. Those that belong to possibly other bodies, there is information being shared across the board. Your bodies might have something similar. So again, try not to reinvent the wheel when you're doing your calculations.
Also, Anjali, just to add, sorry to that, the government have actually updated their link. So for their calculator, they've updated it to reflect this new ruling as well. So if you go to the gov.uk website and use the annual leave calculator, although you know it's for individuals mainly, you can double check things on there.
Fantastic. We'll try and put a link in to the Q&A when it comes out to you, so you don't have to look much further for it. I'm just going to move on to Donald for the next question and this caused a lot of head scratching and discussion amongst the HRC people that you see on your screens today and myself, because I kept challenging them on this. But the question was, how far should we go back when backdating payments? Over to you, Donald.
Yeah, sure. So the legal position is there's a 2-year backstop on any claims for backdated holiday pay. But it has caused some confusion when that backstop applies from. But the answer is that it goes back from the date the worker brings a tribunal claim. But of course, we don't know when that's going to be. We have no idea. So that raises the question: how would employers handle it to try and keep themselves safe? So I thought the best way to do it might be to look at a couple of different scenarios. So if you've got a leaver, for example, say their leave date is, for the sake of argument, the 31st of July, 2022. They got 3 months less a day if they want to take any action to do that. So you're probably going to find out about it as an employer with approximately 2 months after that 3-month time limit to then bring a claim. You're probably going to find out that they've done that they're going to take action somewhere between that. So I would say perhaps work on the basis for a leaver 5 months from their leaving date. You might be looking at a claim. With current staff, I'm assuming here that you're one of those employers who is going to correct the payments going forward. We come on to some of the options later on in this discussion, I think, about how people can keep themselves safe. But assuming that you're looking at an August payroll and your figures are completely incorrect at the moment, because they probably will be, not at the time to do anything about it. Figures are wrong, so they then have 3 months from that date of the incorrect payment to bring a claim, and again approximately 2 months after that to bring their claim if they're going to do that. So what you could do, there's a couple of options available to you. You could either make a rough calculation of when you think a claim might come in and then backdate the pay for 2 years from there. But of course, as I said, we don't know when that's going to be. Really, we can only kind of guess when it might be. But another thing you could do is backdate the pay for 2 years from the date you correct the issue. So before you've even looked at bringing a claim, so okay, you will end up paying a little bit more than you might have hoped, but actually you kept yourself safe, because by the time they decide to bring a claim, you've already made all the backdated pay that you could, so you covered your 2-week period. So that's 2 potential ways you could do it if you're going to be an employee who made the correction.
So with your August one, just to clarify, if, for example, an organisation still hadn't made any corrections because they're still working through it for the September payroll, then your point about going forwards is again September. And again, if you haven't made those corrections by October, your stopgap is there. Is that right, Donald? Just for clarity.
Yes. So 3 months minus a day from the underpayment. So if you continue to make underpayments, it's an ongoing problem. But once you've made the correction, the time limit then starts to run for taking any action.
Okay. And then one of the questions that we discussed is if there has been communication to confirm that there are changes afoot, with loose reference to this particular case for any reason, without the school wanting to commit anything or the organisation or charity wanting to commit anything, the timeline starts from there, was one of the questions that I was posed to you. Is that right?
So you're sorry if you're not actually. So the time limit hasn't started to run yet, you mean?
Yeah, so the idea is that they understand that there is a correction to be made. They have communicated to the staff that there is a correction to be made, and therefore your timeline starts from that communication, in theory.
No, because you still haven't made the correction. You've just told them that you're going to. So it's when you make the correction, the time would start to run then.
Thank you, because that was confusing some clients as well. An interesting one that we did get asked, how does the furlough affect the holiday pay calculations? And I did groan at this one, but hopefully Donald can set us on the right path.
Sorry.
Oh, it was, how does the furlough affect the holiday pay calculations?
Oh, yeah. So that's an interesting one, because the Supreme Court hasn't actually answered this point. So what I've done is I've looked at how the government were dealing with furlough and holiday pay back in the day when furlough was still a thing. So looking at what they said was, they said an employer shouldn't automatically pay a worker on holiday at their furlough rate unless the employer has agreed not to reduce the employer's pay whilst on furlough. So that's kind of suggesting to me that they expect holiday pay to be at 100%. They then said if a worker on furlough took annual leave, an employer must have calculated and paid the correct holiday pay, and there was an obligation to top up if that was reduced whilst on furlough. So again, suggesting it's expected to be at 100%. And they then said workers who were furloughed but now returned should continue to receive the correct holiday pay. So again, suggesting the same thing. So I think there are options. An employer could take the risk and say, no, actually, we're not going to pay the whole thing. We're going to base it on their furlough pay, but then accept that there is a risk of claims. But it seems to me, looking at what I'm seeing, that there would be an expectation that any furlough periods that fall in that reference period would be topped up so that they're getting 100%. Because the guiding principle is, looking at everything the government were doing, is that you shouldn't lose out in terms of holiday pay from having been on furlough. So I think that there'll probably be some carryover looking at that.
Thank you. I have noted that we have got questions coming in, so I'm going to give Donald an opportunity just to have a read through them and see what he can answer. So we are going to move on, but don't fear, we'll try and answer as much as we can. So the next question is actually for Joe. What types of contracts should employers be using for the various types of worker that they engage with?
So what we'll do is we'll go through the 4 different types of contracts. So we've got permanent employees, we've got fixed term employees, we've got casual workers, and we've got contingent workers or contractors. So perm contracts, typically this is going to be for your teaching staff who are, or other staff that are on regular hours. This could include your TAs, it could be catering staff, or it could be property as well. But the key distinction here is that they are regular hour workers and it's permanent regular work, and there isn't an end date to their employment. For fixed term employees, they have the exact same rights as the permanent employees, but typically they're going to be your IT or project staff, so your invigilators will also come onto this point. But one of the key distinctions here is that they're going to have a clear start and end date within that contract. They're going to have a clear purpose of the assignment, and they will have the same rights as a permanent employee. Casual workers. So the term casual worker describes an individual who's not part of the business or a permanent workforce. So this could be your mobile workers. So the case of Mrs. Brazel, who was a mobile music teacher, would also fit under this section as well in terms of casual workers. But it's a catch-all phrase because it's used to describe someone who doesn't have a fixed or minimum number of hours that they must work each week, and with no guarantee whether they'll be engaged to do further work. Casual workers may still be regarded as permanent part-year workers, depending on how their contract is worded. And then the final one is about contingent workers or the self-employed. So this typically will be people coming into a school to do a project. So it could be an outsourced, such as security or IT. But the premise of this is really that they're not on your payroll. They're not going to be entitled to holiday pay from you. The contingent workers are individuals that are not on the payroll, but instead provide independent services to the school or organisation. Their self-employed workers don't generally receive holiday pay, and they should be provided a contract which is relating to services, so not a permanent contract, a fixed term contract, or a casual worker contract.
So I think a lot of food for thought. We'll give you the definitions, as I said, when we send out the Q&As for you, but we had a lot of questions around where people fit into a casual sort of regime, a fixed regime, a fixed term regime. And I don't think there's a straightforward answer. Each of our organisations that approached us, really you have to get to the crux of what it is that they're doing for you, how it's monitored, so many different things to look at. So that could be one where you've got a specific question you might have to come back to Joe directly on, rather than it being answered here. But one of the questions we've had quite a lot of one of the areas we've had a lot of questions on is, if we use a fixed term contract or a casual worker contract, don't we have to carry out DBS checks each and every time? So back over to you, Joe.
Yeah, and the answer to that is yes, but it's not as onerous as it seems, because there is a process in place that the individual can pay £13 a year to register with the DBS update service, which means that in practice the employer can simply log on to the DBS update service and get the DBS results of an individual or worker instantly. So all you need is the employer's name, their date of birth, and their DBS reference number to do it. And all employees need to register for the update service within 30 days of their DBS certificate being issued. And the update service data is updated in real time as the employer continues to pay their £13 annual subscription.
Thank you. One of the questions that I know has been coming up, and it's been coming up with the webinars that the lawyers have been putting on, and people have been saying to me they're getting sort of differing answers on, but we thought we would tackle it. We're going back to Donald, who I know is furiously trying to answer questions as they're coming in as well. But Donald, if you could just answer this one. Do we include overtime when calculating holiday pay?
I think it depends on the type of overtime you're talking about. So there's been case law on including overtime in holiday pay. And the rule is, so compulsory but non-guaranteed overtime does have to be included. If you're looking at, say, for example, I know we're dealing with a lot of schools today, so just taking an example off the top of my head, a boarding school where overtime is not compulsory, but it's regularly worked. Then yes, I would probably say that should be included. Whereas if you've got a day school, for example, where overtime is every now and again fairly sporadic and completely voluntary, then probably not. Some employers might think that the easiest way just to save any potential litigation, given that the courts keep expanding what needs to be included in the holiday pay, is just to include the lot. But again, you can also take the approach of we'll check everything on a case-by-case basis and see whether we should include it or not.
Thank you. Yeah, it's a difficult one, isn't it? Because I think that would come down to one, resource, ease and cost of, again, trying to get that information, because it can often be quite difficult depending on how good the payroll records are. We are going to go back to Joe. Are there national minimum wage implications with this ruling?
So in short, there is, where the salary is paid for the total working weeks in the year plus 5.6 weeks holiday, this might reduce the hourly rate to below the national minimum wage. And I guess the national minimum wage currently is £9.50. And what it's probably worth people doing is going back and checking that all staff salarised employees are receiving in excess of that, so it doesn't become an impact or a consideration for that.
Yeah, so just when you thought the calculations were complex enough, it's a national minimum wage we need to be careful of as well. And this is quite a good one. Sorry, we're back to you, Donald, but won't this decision mean that part-time workers get better treatment than full-time workers?
Yes, it certainly will in the case of part-year workers. And the Supreme Court actually recognised that was the case, but then they said that there was no law preventing that from happening. The obligation is to ensure that part-time workers don't receive any less favourable treatment. So the answer is yes, it does. That particular brand of atypical worker will now receive more favourable treatment. And I suppose at its most extreme, you could have someone who worked for, I don't know, 1 week in a year and still then be entitled to 5.6 weeks holiday in a way that regular part-time workers who work every week in the year are not. So yeah, it does have a big anomaly in there in terms of favourable treatment. But yeah, the Supreme Court recognises that. So
yeah, it's a bit of a headache, isn't it, really?
Yeah.
And I think it's the flavour that I'm getting from the client base that I've talked to is the disparity in all of this. You know, the entitlement suddenly just from working, as you say, for a minimum amount of time on the off chance, and suddenly you're entitled to 5.6 weeks of holiday pay is seems to be a little bit excessive, doesn't it? And I know some of the bodies that I'm talking to feel the same way. So I think watch this space ultimately. Dinah, we're going back to you now. What happens if we have a part-time year worker who did not work this year but worked for 3 weeks last year? And we're getting a lot of those sorts of discrepancies.
Yeah, we definitely are. I've had a few from schools recently, and I think when this ruling first came out, I couldn't get my head around it at all. I kept thinking this can't possibly be right, but yes, it is actually right. So the worker will still need to receive 5.6 weeks statutory holiday entitlement for the year. So the workers' holiday pay, like I said earlier, will be calculated by going back the 52 weeks from the date of the holiday, and then if no weeks were worked, going back as far as, or not enough weeks were worked, then going back as far as 104 weeks. So they will still be entitled to their 5.6 weeks holiday pay, because the 3 weeks worked last year will fall into the 104 week bracket that we're looking at. And to calculate the weekly amount of holiday, you would take the total earnings for the 3 weeks and then divide that by 3, because they've only worked 3 weeks, and you have to discount any weeks they haven't worked. So you take the 3 weeks divided by 3, and that gives you your weekly annual leave amount. And then that 3 weeks, that weekly, average would then be times by 5.6 weeks to get their overall holiday pay.
So again, something that potentially those that have access to some weird and wonderful spreadsheets that are calculating this for them, it does cover that, doesn't it?
Yeah, I mean, where you've got a worker who's only worked 3 weeks, it's actually makes it a bit simpler in a way, even though it's completely disproportionate in terms of how much holiday they're getting. It does make the calculation slightly easier. But where you've got, a lot more, differences and variations in and patterns of when people and how people are working, it becomes so much more complex. And that's where things like the spreadsheet that ISPA have kindly produced have been really, really useful. But yeah, it can be very, very complicated.
Yeah, no, I totally agree. So one of the things that we're getting asked more and more of is actually what can organisations, charities, schools do to reduce their risk in this area? And I think we've got a few on the Q&A as well asking the same sort of thing. So I'm going to leave that with Dinah to just go through some of the options. And just to remind you, we are not advocating any of these options. We're just telling you what is available to you, in case you're sort of thinking, oh gosh, Moore Kingston Smith said we could do this. Just be very mindful that whatever you choose to do, you've got to do, and it's got to be right for you as an organisation. So over to you, Dinah.
Oh, thank you. Well, yeah, like you say, Anjali, there are a number of options, and the first one, which probably most people will like the sound of, is to do nothing. And you can do nothing and continue to calculate annual leave entitlement in the way that you've been doing thus far, and in hope that no one brings a claim. However, if you do this, obviously we would advise you to still calculate your liability and accrue and budget for that, so that you're not going to come up against any nasty surprises that you can't then afford to rectify at the time. So that's one option. However, if you correct the payments going forward but don't backdate the pay, that's another option. Or you could dismiss and re-engage any permanent part-year workers only onto new contracts. And when I say new contracts, I'm talking about contracts that will enable them to no longer be classed as permanent workers. So with both of those options, so correcting the payments going forward, but not backdating, and dismissing and re-engaging on new contracts, that does then break the series of unlawful deductions, meaning that employees will have 3 months from the last underpayment to take action. And if they don't, then any claims would be out of time. So if you do either of those two things and you wait your 3 months or thereabouts, then you're kind of in the clear and you've eliminated any liabilities. Or the least risky option is being transparent. And what I mean by that is going the whole hog in terms of being transparent, notifying all your affected staff to let them know that this ruling has meant a review of holiday pay and how that's calculated. You can also lump into that as well, because it might be helpful, a review of the types of contracts that people are on, because then later on when you do come to have to change people's contracts, it won't be a massive surprise and they'll realise that it's as a result of this whole ruling. And let them know that you'll be in contact about it with any changes once you've done your review. Then you can inform the employees of any past underpayments and you could pay them. And if this is coming up as a large amount of money for you and for your business or school, you could agree with employees that this will be paid to them over a period of time. If cash flow dictates that you can't then pay it all out in one go. Then you could correct the leave entitlements moving forward for the future, notifying staff again how this will work moving forward, how their annual leave calculations are going to be calculated moving forward, and what that will mean in terms of what they're going to receive for holiday pay in the future. And then finally, you can, as part of that whole process, consider them making a change to any permanent part-year workers' contracts who only work a small proportion of the year, especially because those will be the ones where, the amount of annual leave you're having to pay out is hugely disproportionate to what you're used to paying out. So, for example, you could move these types of people over to fixed-term employment agreements, or you could move them over to what we call casual worker agreements. And what I mean by casual worker agreement is where there is, I think as Joe was explaining earlier, there's an end after each assignment, so no agreement exists between employer and worker as at any time that worker isn't actually engaged in the activity. So if your contracts are carefully worded in that way, that's something that can happen. And ideally, if you're using fixed term employment contracts, then you will have gaps of service between each one of at least a month, so that you can avoid someone claiming continuous service of a series of fixed term contracts, if that makes sense. So those are the options, from probably most risky to least.
I think we have seen variations. I think to be fair, I think with the most risky option, you really do need to be careful that you might have sleepless nights for 3 months, because it might not pan out the way that you think it might do, as more organisations might go to the less risky option, which means that people that might have moved jobs will get wind of the fact that they're entitled to something and go back to their former employers if that's the case. So that's my nervousness as well on
That's right.
on the do nothing approach.
Yeah, and the other thing is, like I think I've said many times, obviously this is quite a widely publicised ruling, especially within the school sector. So I feel that people will have an understanding of it and may be expecting something to come of it as well. So, and you've got to also think about reputation, you know, and employee relations issues that may result if you do nothing. You know, that's all part of, you know, that the whole employer, you know, how you're perceived as an employer and how that could damage your reputation in the future is also worth thinking about.
Absolutely. On our list, which we wanted to tackle, was that we had a couple of questions that were fed through to us quite early on. So we thought we'd read them out and just tackle this, because that might answer some of the questions coming through on the Q&A already. If someone works Thursday, Friday and Monday, and possibly term is starting on the Wednesday, does that count as 1 week starting on Thursday or 2 weeks in line with the calendar week? It makes a difference to the average weekly pay. So back to you, Dinah.
Yeah, so when this question came through a couple of days ago, I must admit I did have to look at this, because it was kind of, oh God, I hadn't even really considered that. But it seems that ACAS state that a usual working week for calculating holiday pay usually starts on a Sunday and ends on a Saturday. So if you're using that ACAS reference period in this instance, because that week the person only worked Thursday and Friday and the Monday wouldn't be included, then that particular week wouldn't be included in the annual leave calculation. You wouldn't use it because it's not a full working week, if that makes sense. So if you haven't got a full working week, and if your working week is different to that, so and to find that out, you might need to speak to your payroll provider. I don't really know how that would work, but if, for example, your pay is calculated by a week ending on a Wednesday, then you should treat your week for holiday pay as starting on a Thursday and ending on a Wednesday, and then work from there. And where people haven't worked a full week within that Thursday to Wednesday, don't include that week in your calculation. Is how it's supposed to be done.
So not that clear cut.
Not simple at all.
No,
not
it's
simple.
A lot of head scratching, I think, possibly is going on.
Yeah.
The implementation of this change to ongoing payroll processes is quite significant, hence it's been delayed. What are the implications, and how can this best be managed in the interim so that the change can be fully integrated into HR and payroll processes?
Yeah, I think again, it's going back to, if you've got the luxury of having a payroll provider, I know not everyone has, but if you do outsource your payroll and you've got a good provider, then they should be able to help you with this. If you haven't, unfortunately, we are in a position where we're probably going to end up having to do manual calculations for any employees or workers whose hours and pay vary. It's going to be manual calculations in order to do it accurately. But like I say, I do know, because of the practicalities of this and how impractical it is, I do know that there are, some clients out there who are just working on the basis, they're still doing the calculation, but they're not doing it every stage. So, rather than saying, right, I know that someone's taken annual leave now, so now I've got to work out their previous 52 weeks and I've got to work out their weekly average to pay them correctly for this particular period of annual leave. They're just starting the leave year and saying, right, we're going to look back over the past 52 weeks from here, and we're going to use that as the basis of our pay for holiday moving forward, because to do it the other way is so onerous, so time consuming. We just don't have the time, and we're going to take the risk and do it that way.
I think thank you. I think this one's been answered, but I think this is again just to confirm, if a permanent staff member is paid throughout the year for work carried out in term time only, lab techs, catering staff, cleaners, for example, does the ruling apply?
Say the beginning bit again, Angeli, sorry.
If a permanent staff member is paid throughout the year for work carried out in term time only, so I'm assuming that is a term time only member of staff, so the lab tech, the catering staff, the cleaner, does the ruling apply?
Yes, it does, yeah. So they are still entitled to their full 5.6 weeks annual leave, and the pay would be calculated in exactly the same, well, actually, no, with term time only, it's normally included in their salary, isn't it? I think. So it would be pre-agreed in terms of the salary they're getting. So yeah, but it would be based on 5.6 weeks as opposed to it might have been based on less previously before this ruling.
Okay, in the same vein, I'm trying to pick up sort of a theme here so we could cover all of them. So sorry if I'm doing this out of sync for those asking questions, but if you have a permanent worker, i.e. no end date, term time only of 35 weeks, they currently get 5 weeks holiday, should they be receiving the 5.6?
Yes, they should be. There is a very similar theme to this. Is what I meant. A lot of the questions that were coming in, actually, that have been coming in over the past few days, were the answer was very similar. 5.6 weeks. Yeah, we had a bit of a joke, as we could say it in many different tones of voice, but still it would be 5.6 weeks.
Well, I think this one will be the next easy one then. Based on previous questions and answers, would casual workers' entitlement still be based on the 12.07 on hours worked, or 5.6 prorated down to the period work? It's 5.6 weeks, yeah.
The 12.07%, you know, I would advise not to use that at all moving forward, because yeah, it's just going to confuse matters, even though technically, you know, as we were saying earlier, for any excess holiday up above the statutory minimum, you could say, well, for our casuals, we're going to work, or well, not for our casuals, but for our permanent 0 hours, maybe you might have given them 12.07 before. You could say for that little extra that we give them, we're going to base it on 12.07 if you wanted to. But other than that, don't use 12.07%.
Would a series of fixed term contracts not be deemed to be permanent if they happened over an extended period of time?
Donal and I were talking about this the other day, weren't we, Donal? And we think that there's an outside chance if there's not enough of a gap. But Donal, do you want to explain?
Yeah, so there has to be, the way that sort of law works at the moment, there has to be a gap between contracts in order to avoid it being seen as continuous service. So with everything like a series of fixed term contracts, there's a risk that someone could say this is window dressing. But if there's sufficient gap between the two one contract ending and the other beginning, I think that kind of reduces the risk somewhat. But yeah, in theory, you could use a series of fixed term contracts for this purpose rather than putting people on a permanent contract. But a true casual workers agreement could be equally useful as long as it's not a permanent contract.
Okay, we've got some more coming in about the 5.6 weeks. So I'm trying to keep them all together. Just to check, for part-time staff on regular hours, holidays are just calculated on a pro rata basis, not on the 5.6 weeks.
Okay, it's still based on a minimum of 5.6 weeks, but you can pro rata it. This is the entitlement only we're talking about. The pay you still calculate in exactly the same way as we've been discussing. So the actual entitlement of 5.6 weeks will still apply to a part-timer who's working regular hours and is permanent and is not part who is not part year worker. They will still receive their 5.6 weeks pro-rated down. So depending on the number of days a week they work, you would pro-rata the holiday accordingly.
Donal, I think this one's for you. If people opt out of the working time directive, do you have to give the 5.6 weeks holiday?
Yes, you still do. That's not part of the working time regs that you can actually opt out of, unfortunately. So I think it really will be a case of pressuring the PM to look at this and look at the effect it's actually having. Because one of the annoying parts of it is the Supreme Court said that they didn't think this would have a major impact, and in the way they normally do, because they're presumably they're not working with it. So yeah, they think it's all hunky dory, but I think the lawmakers might have a different view once people start talking to them about what this has actually done.
Yeah.
But that's the only way, I'm afraid. I don't think opting out of that bit will work.
Unfortunately not.
No.
So this is one I don't think we've actually covered this one, but I could be wrong. If someone has left your employment, but they've been underpaid in accordance with this ruling, I assume, are still within the tribunal time limit, what are you supposed to do? So basically, are we contacting people that have left us, or are we just simply dealing with the people that are currently within employment, even though the ones that have left us are covered by this?
If it's entirely your choice. As a commercial decision, I'm going to push you either way in that one. You could say let's clear the decks, back pay everybody, make sure that nobody could possibly come back, or you could just say, well, look, they've left, wait for the time limit to expire and see what happens. See if they come back, and just concentrate on your current staff. Entirely up to you. Really, how you would handle that. But both are valid options, but it's entirely up to you what your liabilities are. You might want to do the calculations first before you make your minds up, I think.
Again, very anecdotally, and I might get myself into trouble here, but I am hearing across the piece that most are just dealing with the employees that are left with them, as opposed to trying to find employees that have left in the last 2 years, if I'm being honest. And I think on that basis, depending on which payroll your correction hits, then Donald's initial conversation about how you calculate the 2 years and where you're at risk is that kind of 3-month period. So that if, and Donald, please correct me if I'm wrong, but basically, if you haven't contacted someone and you've corrected your September payroll now, you've got someone having left you has 3 months from September to bring a case. Is that right, Donald?
Yeah, I mean, there's a process they have to go through before that, but which is notifying ACAS that they intend to take things further, and you'll probably find out that they've done that in the next month after the 3-month time limit has expired. And then that's why I kind of said maybe two months after that's been claimed to allow that process to take place. But yeah, you usually do get a heads up, unless there's someone pig-headed who says, I don't care, I don't want to settle, I just want to go straight to the tribunal to make a point. So you usually will be given a heads up that someone's intending to do something.
And at that point, you could settle the claim at that point, couldn't you? If you were so inclined, yeah.
So we've got a couple of questions on the calculations themselves. How do you calculate weekly pay if you are paying monthly based on timesheets submitted?
Yeah, I think I tried to answer that question. I tried to type the question in for that one, but I'll be honest, it's probably a question for a payroll provider. I don't actually know the answer to that without looking into it a bit further. So I will, though, look into it following this and see if I can come up with some answers. So yeah.
We might try and give you some guidance on when we issue the Q&As, I think.
Yeah, I think that's a good idea. We can try and cover that off.
At what rate do you pay the holiday pay if they've received a pay rise during the reference period? Do you pay them according to the earnings at the time it was earned, or the rate of pay at the time the holiday pay is paid?
It's the rate at the time the holiday pay is paid, and certainly if we're looking at people who aren't salaried or who have got varied hours or varied pay, and they get a pay rise, then that increase will be included in your average when you're looking back over your 52 weeks. But if they're not variable pay or variable hours and they're regular, then yeah, it will just be the rate of pay at the time they take their holiday, including their increase, if that's happened.
This one made me laugh, this one. What's been the logic to this ruling?
Oh,
I'm not sure there is one, but
over to you. Attempt that one.
I can attempt it. I'm not sure I'm entirely going to do a great job at this, but so what happened was essentially these holiday pay rules came in the first instance from the European Union. So they said you have to give but you have to implement regulations which give people the right to pay time off, and their chosen point was 4 weeks. The UK government, in its wisdom, decided actually we want to be more generous than that, so they kind of gold-plated the regulations, and they gave. So we've now got, the current position is 5.6 weeks, but the way they've worded the regulations, that's pretty much what's happened. They've played on the wording of the regulations, and the judge has said that the way the 12.07 method, albeit that was ACAS approved, doesn't fit the more generous working time regulations. So that's what's happened. It's just about how it fits with the wording of the regulations. So if we can, if it's possible to get them to tinker with that, it really will be, that will be the only way to change it, really. But you're right. It doesn't. It doesn't stand scrutiny if you look at it from a common sense perspective, because, as I say, you could have someone working for 1 hour a week, and yet if they're on a permanent contract, hey, they're still entitled to 5.6 weeks annual leave. So no, it doesn't make sense from that perspective. But it all stems from the government having implementing this more generously than the EU required them to do.
Yeah, and I think there are a lot of people out there that really unhappy about this ruling. So we expect there to be pressure to amend exactly what Donald said. You can't change the decision, but you might be able to amend the working time directives on it. So watch this space ultimately, but it doesn't help you at the moment, unfortunately, because that will take time. A good question, actually. Do staff on 0-hour contracts fall into the scope? They believe that you have already said yes, but they just wanted to confirm.
It depends how the contract's worded, but yeah, if they're a 0 hours worker and they're on a permanent contract, so there's no breaks when they're not working, then yes, they would fall into this ruling and they'd be entitled to their 5.6 weeks.
I think again, trying to group some of these, I'm conscious of time. Oh gosh, we pay some teaching staff and support staff a set amount for a lunch duty. Does this get included as part of the entitlement for holiday pay?
I would say yes. If it's a regular everyday lunch duty payment, then yeah.
How do you trigger holiday pay if the worker doesn't claim?
Meaning?
I think what they're after here, and correct me if I'm wrong, for the person posing the question, it's about actually you as an organisation just coming up clean for your current employees to say this issue's arisen, we're correcting all our, so it's irrelevant whether the employee comes to you at this point, you're taking the decision to deal with the problem. We have said in this particular webinar, it's up to you whether you want to actually contact people that have long since gone for that 2-year period of when you've triggered the calculation. So I think that's what you're asking here, is if someone's not coming to you, you're offering this up, I think is the point there, but please rewrite it if that's not the case, ultimately. Is it riskier to resolve the payroll moving forward for all impacted staff, so just what I was just saying just now, but only offer back pay to those who are more aware of the ruling? So you're kind of doing a bit of half and half. I think I know the answer to that, but I'll let you answer it.
I mean, I feel that with things like reputation and things like that and employee relations issues in mind, I'd say that you treat everybody fairly and equally and get everybody on the same playing field with it, and but again, it is a commercial decision. It is completely a business decision. So you could in theory tackle the ones that are shouting loudest about it and deal with those, and probably that's how it would work naturally anyway, because but yeah, you could leave the others and hope that your 3 months or thereabouts passes and they're then out of time to make that claim, and then you're back on an even playing field, because moving forward all of the holiday pay will be correct.
Some good questions coming in, and I think we've had a couple on the same vein, so I think we need to tackle that as well. There are employees who actually don't take holiday but are paid for it. What's the trigger? And then the other question is about, well, employees in who are getting caught by this don't actually tell you that they're taking holiday. So I think, just paraphrasing here, we're paying people for holiday pay that traditionally would not take holidays because they are falling into that vein of they're not permanent people.
They're casual.
Yeah, they're casual. So I think there's confusion, isn't there? Well, why are we paying them holiday pay when they don't actually take holiday? Can you enforce them to take holiday? I suppose would be the common sense question, wouldn't it?
Yeah, this has been the thing for years and years and years since I've been, working in HR about casuals and holiday and how does it work, because there was a ruling about not being able to do what they called rolled up holiday pay, so include holiday pay in people's actual pay. And then there was a thing about, well, as long as you're identifying it separately on the pay slip, then it's fine. But overall, casuals, it's true, they can't usually, and they don't usually take actual holiday because they're not around long enough to need to take holiday from you as an employer. But you do still, under the working time regulations, have to give them their 5.6 weeks holiday. So usually what happens is, and in my experience, is that the employer will calculate after each assignment. So say they've worked for you for a couple of days that week, and they're not going to work for you for another couple of months or something, you would calculate those couple of days, you would work out what their annual leave entitlement that they've accrued in those 2 days, and then pay them it. I mean, there's no other real way to do it unless anyone else has got any examples in their experience.
And a good question following on from that is actually, when do you pay these people? So someone that's not actually asking for the holiday, when should this be paid?
So again, are you talking about casuals here?
Yes, casual worker.
Yeah, so where they may not be asking for holiday pay, but you want to correct it, when to do it. Yeah. There's no right or wrong with that, obviously, but like I say, usually it's done on the basis of when they've actually done their work. You would just automatically pay them for the holiday that they've accrued for that time. So I don't know if you could work it on that basis or not, but if you've not been paying them and you need to do a backdated lump sum, then I guess it depends on, again, your cash flow, what you can afford, in order to make a decision as to when to make that payment to them, really.
We do have a few contract questions. I'm not sure we can answer these because I think they're very specific to the entities, but I'll let the team decide. What would the objective justification be for using a fixed term contract as opposed to a permanent term time contract?
Well, from my point of view, you use a fixed term contract, I think, like Joe was saying earlier, where you have a specific piece of work that has an end to it, usually. So it has a beginning and an end. It has an end date. So, specific projects, specific things. So the invigilators, for example, if they're coming in for a specific period of time, and it only happens once a year and it's the same period of time every year, you might say, well, that's the fixed term piece there. That's when we need them. We need them to start in this month and end in this month, and then they've done their bit. So that's when it's good to use a fixed term contract rather than a permanent one. And that will enable you to then not have to pay, not have to go with this new ruling.
And we tend to see the sort of permanent term time contracts, and it depends on the organisation, but we see it in teaching assistants, for example. You only need them in at term time to support. Catering, for example, term time to support. Certain level of cleaners coming in, again, term time. So we do see a faction of the employees only needed for term time or certain periods of time. So there is a distinction, I think. Ultimately, I'm a bit disingenuous because I'm sort of stopping short of a minute, but I think it'd be hard to get into a question. The team have tried to answer as much as they can. I can see on my list that we still got 18 open questions. What we will try and do, we've answered 31 here, some of them are in the same vein. We will try and collate as much as we can and send them out to everyone that's registered, just to give you a little bit of guidance. So wait for a couple of days to allow the team to do that. and the team will put their details on the bottom of that to allow you then to come in and contact them directly should you have more queries, because it is complex. You have specific questions for you as an organisation, and we've just tried to answer as many as we can because we were inundated with these questions, and a lot of them very similar. So we just thought this would be very useful to answer all of these in one go. So can I just thank you for for coming in and listening to us. Sorry we haven't got time to go through absolutely everything, but hopefully some of the information we send out after this will be useful. So thank you and have a really good afternoon.
Thanks,
Goodbye.
Anjali.
Thank you.
Thank you.